I mean, so this case we are looking at has arrived at the International Court of Justice, the Court of the United Nations, by way of the General Assembly of the United Nations, who referred a request for an advisory opinion to the court. And this advisory opinion, this request, bears on the status of a set of islands in the middle of the Indian Oceans called the Chagos Archipelago. Now, the Chagos Archipelago now is part of a British Indian Ocean territory, which is another term for a British colony. It used to be, however, administered together with Mauritius when it was a colony of the United Kingdom. Now, in the 60s, when Mauritius intended to become independent from the UK, there were negotiations about the Chagos Archipelago and whether it could still belong to the UK after Mauritius' independence. Now, Mauritius essentially signed an agreement with the UK which allowed the United Kingdom to detach the Chagos Archipelago from Mauritius, retaining it within the United Kingdom. Shortly after that, the United Kingdom set about building a military base on the central island called Diego Garcia, together with the United States of America, a military base that has now been used in various efforts in armed conflict for the United States. However, the United Kingdom also, in that process, deported or relocated the people who used to live in the Chagos Archipelago, the Chagosians. They lived there for at least 5 generations, were removed by the United Kingdom mainly to Mauritius. Now they live in Mauritius in very poor conditions, also partly in the UK, but also in the Seychelles. So the case implicitly is about the Chagosians, but it comes around as a dispute, or informally speaking, as a situation between Mauritius and the United Kingdom. And the General Assembly asked the court to determine whether decolonization was actually completed with regard to the Chagos Archipelago, and if not, what the legal consequences of this were. Now, we assembled a set of scholars, academics, free minds to talk about this subject. The idea being that we get together and see whether there were points that are being missed in The Hague.
I've been interested in the Chagos case for quite a while. I interviewed a few of the evicted community, first and second generation Chagosians.
Of course, the whole Chagos thing is super interesting and super problematic in so many ways: human rights, environmental, legal issues, military issues.
It throws up so many curious and interesting and important issues of international law.
My own perspective is from a human rights point of view. Particularly, my interest at the moment is the environmental dimension relating to the marine protected area.
Most notably, of course, the United Kingdom has argued that the court should not take this case because it is a bilateral dispute in the end, which requires the consent of the disputing parties to international dispute settlement. Now, the court itself requires compelling reasons not to accept a request for an advisory opinion by the General Assembly. And it seems that in this case, the fact that the General Assembly thinks this is of relevance to the international community at large is proof of the fact that this is not just a bilateral dispute.
And one point actually may be that the rights of Chagosians are not given due regard in this process because no one really represents them. So this is one point that seems really important to me. The human rights of the Chagosians and the right to self-determination of the Chagosians is something that should not be forgotten in this process.
And of course that's also interesting because of the kind of fragmentation of the community as well within the UK and then within the Seychelles and in Mauritius. And I think that will be challenging as well when it comes to the ICJ in working out the kind of second limb in discussing the kind of remedies and how resettlement could happen if it were to give instructions on that.
The impact on other states whose interests might be directly engaged by the Chagos proceedings. So I was thinking in particular of states who have themselves had territory excised from them during the decolonization process. So specifically Cyprus, which has the sovereign base areas which were created in 1960 as part of the constitutional settlement that led to the creation of Cyprus as an independent state. Then Mayotte, which was excised from the Comoros Islands, and which the Comoros claims should rightfully be part of their territory. But France has integrated the Mayotte into its own territory. And then Madagascar's claim to the scattered islands, the Île d'Éparses. So these are unpopulated islands, but they were also excised by France from Madagascar in 1960 on the eve of Madagascan independence. You have a variety of irredentist states around the world who lay claim to adjacent territory. I'm thinking in particular of states like Argentina, with their claim to the Falkland Islands, Guatemala with their claim to Belize, Spain and their claim to Gibraltar. And all of them will be looking very carefully at what the International Court of Justice says in case there's anything that could help their claim.
The arbitration that occurred prior to this hearing before the ICJ and how it's relevant to the current proceedings and whether it'll inform the opinion of the ICJ or whether there will be consequences flowing from any opinion that's given as regards the continued existence of that huge marine protected area around the Chagos Islands. At the moment, the marine protected area is in limbo because the International Arbitral Tribunal ruled that the UK had created it without due process under international law. What will Mauritius do about the marine protected area, given that one of the questions being asked of the ICJ is about resettlement? It's been suggested in a WikiLeaks document that one of the motivations for the marine protected area was to prevent resettlement. Now clearly the ICJ case is looking at that issue, that question of resettlement. Mauritius has indicated it will resettle the islands, but if so, what will it do about the marine protected area?
I met Chagosians who wish to go back. And interviewed them and spent time with them and with their families and everything, and was trying to find out for myself whether their culture got subsumed into the respective culture they're living in or not. And my personal answer is not. These people have really had a hard time, and of course they have been integrated in other societies. But the interesting thing is that a certain amount of discrimination has happened in these other societies that make them still feel that they are a ethnic group. And with that identity, that has actually happened through othering, through other groups sort of telling them, oh, you're not from here, you came from these islands, that they have formed an identity in exile. And this, I think, makes it absolutely legitimate for them to return. The most important question is, are these people allowed to return? That is the question. And really the question whether it belongs to Mauritius or the UK is after that. I think any outcome of the ICJ will and should address that and help in making that happen.